For pronouncement of judgment, item 19.
We have allowed the writ appeal, dismiss the writ petition. Apply. My lord, I may be permitted to mention item number 2, my lord. Here I appear for respondent number 5, my lord. I may be allowed time to file affidavit in opposition, 4 weeks time, my lord.
These are the connected matters, 4, 5. 4 and 5, both are connected matters. Yes.
Item 2, my lord. Item 2, my lord.
Okay, 2.
So I have taken consent, my lord. It may be
After summer,
come up after 4 weeks.
summer.
I know time paying for item number 1 lawsuit. Actually, for little lawsuit, may I play lawsuit, this matter may be taken up day after tomorrow.
Day may be taken up. Day after today, day after no, either it will be heard today or then it will go after summer vacation. Summer vacation.
Yes, please, Lordship. Lordship, I beg to mention item number 6, Lordship. Lordship, we have taken concern from the other side. Lordship, my senior is unable to present today, Lordship, due to water logging.
I'm from the respondent, madam.
Lordship, maybe adjourn 2 weeks, Lordship. 2 weeks.
After summer vacation, adjournment, the matter will be listed after summer vacation.
May I please your lordship? Lordship, I beg to mention item number 17. I have taken consent. Lordship, the matter may be adjourned for today. Lordship.
Adjourn.
Obliged.
I pray for listing of a PI, your lordship, for admission in on any date before vacation, your lordship. Actually, on any date before vacation, your lordship.
Second week of June.
Much obliged.
May it please your lordship, I beg to pray before agenda item number 15, lordship. As the senior counsel K. N. Chaudhary, sir, is not available in Guwahati, lordship.
Adjourn.
Your lordship, may I pray that it may be fixed up on 11th, your lordship.
After summer. Vacation.
Daily list for hearing item 3.
Ready?
Yes, lordship. May I please?
Yes.
Private respondents were not represented earlier, your lordship. That is why another day was given.
Still the private respondent is not represented. Okay, fine.
Lordship, page 77 is the judgment and order passed by the learned single judge in writ petition number 2595/2013 filed by the petitioner, lordship. In para 13 of the judgment and order at page 82,
Your Lordship.
Yes.
The learned single judge mentioned that the
Read.
certificate issued by
Read para number 13, read. Para number 13.
Yes, Your Lordship. Yes, Your Lordship. Para 13. In para 13, the page number 82, in the read petition, as was filed in support of the contents on that the read petitioner was appointed, the petitioner had annexed a certificate of one Yudhishthir Nayak with the seal of President Secretary of School Managing Committee of the school in question, in view of the stand taken in the affidavit in opposition that school managing committee had never appointed the petitioner and that Yudhishthir Nayak was also not the president of the school managing committee. In affidavit in reply, the petitioner had taken a stand that he had never stated Yudhishthir Nayak was the president of the school managing committee. That apart, in the affidavit in reply, an appointment letter dated 6/1/2005 was annexed as Annexure 8. The said document is signed by one Yudhishthir Pan, followed by the seal of President Secretary of the School Managing Committee. Yudhishthir Pan and Yudhishthir Nayak are evidently two different persons. Annexure 1 of the read petition is undated. I am coming to this point, Your Lordship, that Yudhishthir Nayak and Yudhishthir Pan are two different persons, and a certificate issued by Yudhishthir Nayak. Lordship, the certificate issued by Mr. Yudhishthir Nayak with seal of President Secretary of School Managing Committee was not authentic, considering the affidavit in reply submitted by the respondent number 6. Here, Your Lordship, this was the opinion of the learned single judge, Your Lordship. This was the in reply to this, I want to say, Your Lordship, that the learned single judge ignored this point, that he's not paid any attention to Annexure 1 and 2 of the read petition. Page 31 and page 61, Your Lordship. Page 31, is the certificate, Lordship. Page 31 and page 61 is also a certificate, Your Lordship. Page 61. Page 61, the name of Yudhishthir Nayak is mentioned. It is Lordship, Annexure 1, page 31 is the certificate where we see the signature of Yudhishthir Nayak with the seal of President Secretary. Now, the question of whether Yudhishthir Nayak was holding the post of President Secretary of the School Managing Committee is clear by Annexure 2, page 32, which is an official letter addressed to the Member Secretary, School Managing Committee, issued by the Deputy Inspector, Block Elementary Primary Education Officer of Block Bihali, District Sonitpur, approving the School Managing Committee, where the name of Mr. Yudhishthir Nayak was clearly visible in the table at serial number 1 as the President of the School Managing Committee. It is page 32 is the letter, Lordship, and there is a table, Your Lordship, and number 1 is the name of the person, Yudhishthir Nayak. And this is an official letter appointing the School Managing Committee, Your Lordship. So Yudhishthir Nayak, whether he was holding the post or not, that is clear from these documents, Your Lordship, that he was the president of the School Managing Committee. Now, Your Lordship, I would like to draw your attention, Your Lordship, to page 60 and page 61. Page 60. This is another application for provincialization of the services of
This
employees in law.
Annexure 2 is dated.
Lordship,
Annexure 2 is dated.
Annexure 2. Annexure 2. Let me see. Annexure 2 to Date is not visible, your lordship, something in,
Not visible, even not, date is not there.
there is a date, which is a Xerox copy.
Date column is blank.
The first paragraph, it is there, it is, this is not, it's okay. Yeah,
The date
in the
column is
paragraph,
blank.
it is 17th, June 17th, 2006. It is for the resolution was taken on that date, your
Notification
lordship.
dated, dispute dated so and so. Members of selection.
In inviting reference to the government, notification number so and so dated dispute June Iman 17, 2006, and resolution passed in the general meeting held for present guardian of all students and other committee members. That date was not missing. Order, the instruction date was mentioned here, your lordship. There is a seal, but the date is not visible. your
Date is
lordship.
not visible, not even date is not there, man.
We are requested to hold the first meeting of the SMC within 15 days in receipt of this letter. Also, the SMC should take up all.
In inviting a reference of the government notification dispute dated 17th of 2006, June 17, 2006. So it refers to a order of 2006.
Yes,
It
sir.
can't be of 2005.
Lordship, this was official appointment. The
Official appointment, even though if it is admitted, then it is
Yes.
not in the year 2005.
I'm coming to that point, your lordship, because 2005, there was no act at all. This act was passed in
So, this is
2006.
sanctity of that letter by the certificate given by you, given to you by this president when no such provision for appointment of the SMSC was there.
Committee was there, your lordship, but this official act and official approval, that was not required. In Vansar schools, your lordship, some headmen of the village, they assemble, they make a committee and they start a school. And it was in the Bihali, your lordship, in a tea garden area, it's a very remote place, your lordship. And some headmen of the village,
If you are claiming benefit of a certificate, you have to prove it.
the school was running in a very informal manner. Before that, before 2006, your lordship, there no act, such act was there. So they were running it a very informal manner. This is why all this happened, your lordship, because the
As
school
per your
headman,
case, school is altogether running in an informal manner. Then how we treat this appointment as a valid appointment in any manner?
later on it happened, your lordship, when the committee was formed, when government passed some rule and government asked for their proposal to.
Ultimately, your claim is based on a certificate of 2005.
Later on also there are certificates and documents, your lordship.
So it may be
Yeah,
initial date of
Yeah,
appointment.
government documents are there, your lordship. I'm coming to.
The question is regarding initial date of appointment. You are claiming that I am appointee of 2005 and therefore this, who are the respondent, maybe he is appointee of 2006 or later date. Therefore, I'm senior and my services are liable to be provincialized in place of respondent number 6 or 5, whatever it is.
This is
So for
not
that,
the only point, your lordship, because I'm coming to other points that here I am mentioning this because whether Yudhishthir Nahak was holding the post or not, on that question I'm coming here. Your lordship, later on that the form they had to submit some form to government.
You please formulate, what is your case? You straight away start from one document, Yudhishthir Nahar. What Yudhishthir Nahar? What is your case? What is the matter? Please tell us first.
Yes, your lordship, I was appointed and when the school was applying for.
Just take a seat. Mr. Majumdar, what is this matter all about? Can you please tell us?
But her claim that she was appointed in that particular school when in the ventures stage prior to the private respondent. Learned single judge has found that the claim for that particular appointment was not substantiated by documents and our provincialization of the private respondent was updated. What my learned friend is.
Based on which document?
Her claim.
Claim was based on which document?
The dias code of the school given later on and also the appointment letters which she is now trying to show. That appointment letter has been discussed at paragraph 13. Lordship, paragraph 13, page 82.
Yeah.
In the writ petition, as was filed in support of the contention that the writ petitioner was appointed, the petitioner had annexed a certificate of one Yudhishthir Nahak with the seal and president and secretary of the school managing committee of the school in question. In view of the stand taken in the affidavit in opposition that the school managing committee had never appointed the petitioner, and that Yudhishthir Nayak was also not the president of the school managing committee, in the affidavit in reply, the petitioner, who is the appellant here, had taken a stand that he had never stated Yudhishthir Nayak was the president of the school managing committee. I'll just pause here for a moment, my lord. Now the assertion is being made that there are documents to show that he was the president and secretary, but in the writ petition, there was no assertion. That apart, in the affidavit in reply, an appointment letter dated 6/1/2005 was annexed as Annexure 8. The said document is signed by one Yudhishthir Pan, followed by the seal of president and secretary of the school managing committee. Yudhishthir Pan and Yudhishthir Nayak are evidently two different persons. Annexure 1 of the writ petition is undated. Writ petitioner has not brought on record any document to show that Yudhishthir Pan was either the president or the secretary of the school managing committee on 6/1/2005. It was necessary for the writ petitioner to explain the same in view of the categorical stand taken by the respondent number 6, that he was never appointed in 2005. The writ petitioner has failed to produce any acceptable material on record to show that he was appointed in the year 2005. That apart, it is admitted position that in the year 2005, the writ petitioner did not pass HSLC examination, and it is not disputed by so-and-so that qualification prescribed for appointment as a teacher in venture school is minimum HSLC pass. What is sought to be contended by Mr. So-and-so is that having regard to the remoteness of the school, the qualification was waived for the petitioner. There are no corroborating materials to support the plea. That apart, the essential qualification cannot be waived. Annexure 3 is the dais for the year 2009-10. After page 19 of the Annexure 3, which is the data collection format, the petitioner had annexed page 20 as highlighted as C teachers. Evidently, C is preceded by A and B, but they are not placed on record. These are corrections in the name of Sarbeshwar Borua, which was earlier written as Bora, and in the year of joining against the writ petitioner. Apparently, 2005 is handwritten. There is overriding in respect of date of birth of Sarbeshwar Borua. There are no initials against the corrections. Typewritten 1 and 2 against the name of Sarbeshwar Borua and Mahesh Tati are found to be typed in blackened box. And there are 2 lines between serial number 1 and 2 which can accommodate another name. Annexure 4 is dais for the year 12-13. The same is without any signature of any authority. No doubt, at page 33 against C, teachers staff detail of Annexure 4, name of the petitioner appears at serial number 2. However, in absence of any authenticity of the document, as also in absence of any explanation of the writ petitioner regarding the corrections in Annexure 3, said documents cannot be accepted at face value. The writ petitioner has taken 2 contradictory stands with regard to respondent number 6, that her appointment order dated 5505 is a manufactured document, and secondly, that the respondent number 6 is a second assistant teacher. The writ petitioner has not brought on record any order of appointment of the respondent number 6 showing a different date of appointment, and in absence of such a document or a plea with regard to the specific date on which the respondent number 6 was appointed, both pleas taken by the petitioners cannot go together. Annexure C of the affidavit in opposition is an inquiry report of the Block Elementary Education Officer Behali. The said report is in favor of the respondent number 6. Learned counsel for the petitioner submitted that the said report cannot be taken cognizance of as there is no seal or signature. There appears to be a signature in the inquiry report. Even if the inquiry report is not relied on, the materials on record leave no manner of doubt that the respondent number 6 was appointed on 5/5/2005. Writ petitioner became eligible to be appointed as assistant teacher only in the year 2007, and there is no dispute on that score. The fact that respondent number 6 was also a member of the Rotowa Gaon Panchayat in the year 2008 to 12 will not disentitle the respondent number 6 from her claim to be provincialized. Respondent number 6 was not an employee of the Gaon Panchayat but was an elected member. At the relevant point of time, the school was a venture school, and it is a categorical stand of the respondent number 6 in the affidavit reply filed against the additional affidavit of the writ petitioner that an elected member of the Gaon Panchayat was not required to attend office regularly. It was the failure on the part of the petitioner to prove her documents or her stand.
Yes.
Yes, Lordship. Annexure 3, about which we are saying that Annexure 3 is the data collection format, the DIAS, and the name of page 36, your lordship. Page 35 is the format, and page 36 is the form where it was said that the name of my name was not there. Here, your lordship. Page 36. This is the format for application. And my name is clearly mentioned in the second column after the headmaster. Headmaster's name Sarveshwar Bora or Borua, and my name is mentioned in the second point, your lordship. The observation, and it was a document. It was the first application, DIAS format. It was the first document in the year 2009, your lordship. Then they have submitted other documents. Till then, I was serving, your lordship. And the name of the private respondent is not mentioned in this form, your lordship. If we do not say that whether I was appointed in 2005 or not, the formal document starts from this document, your lordship. Formality. This was the application for provincialization. And in this document, my name is clearly mentioned, your lordship. And the name of the private respondent is not mentioned here, your lordship. And the learned single judge has observed that, your lordship, there is another gap between serial number 1 and 2. It is an official format, your lordship. It is not made by me. It is not manufactured by me, your lordship. That another name can be accommodated. That cannot be happen. And if it happens also, I am not responsible for that, your lordship. It is an official accepted format that was accepted, and on the basis of that, the provincialization was done, your lordship. And the other observation, your lordship,
Yeah.
That there is a gap, that and other observation, your lordship, I'm coming to that point. And observe that Sarveshwar Bora or Borua, that was also not my responsibility, your lordship. I am not responsible for that. It was official document. I have just collected the copy and I am annexing it, your lordship. And DIAS form, the next is DIAS form. 2009-10 DIAS Annexa 3 and then para 14.
Mr. Majumdar, service of the appellant has not yet been provincialized. Is there any possibility under the new act?
Under the new act, we may examine that. We can examine that. Otherwise, my lord, only venture schools are now being taken up for provincialization. Already provincial schools where provincialization taking place, those schools are not being considered, but there are orders of the learning single judge in the
So even if, even if the position obtaining from the order of learned single judge is accepted
my lord.
and kept undisturbed, even then the appellant was appointed in 2007, right? So that is more than 15 years, 15, 16, 17 years. So someone who has worked for 17 years would definitely be quite senior now. If he was not the first assistant teacher, he was the second assistant teacher. Therefore, though we are conscious that the Act of 2011 has been quashed, but now there is a new Act of 2017. So under this act, is there a possibility of the appellants?
I'll have to take my instructions on that. Otherwise, my lord, there are orders of this honorable court where 2011 we could not accommodate in 2013.
Right.
Those
that's-
teachers are now being, under orders of the court, are being considered.
So why don't you give us that? Because ultimately, assuming that she succeeds, it will be a prospective regular provincialization. So if the appellant is otherwise entitled to and the department is willing to provincialize due to the long length of service, we'll close the matter.
I'll just have an instruction, Lordship. will
Because
put me away.
technicalities apart, a person who has worked for so long,
Yes.
it will be very legitimate for, on a technical count, she may or may not have a case.
In fact, my division bench orders are there which says that where the 2011, under 2011 Act, we cannot entertain the claim. There also, they have been referred to the 2017, when someone else was provincialized and they make a claim. Those, there are judgments, my lord. I'll place those judgments also on the next week. Punavati Brahma. Punavati Brahma. Consider.
What is the position? Say there's a maybe. Yeah, it's perfectly clear. I know this.
School. I was more literate than them because I was in class 9. So they requested me that you also come and teach the children, tea garden labor community children, your lordship. So I associated myself with the process. I start working there. It was not for salary and anything. It was my social service, your lordship. And then when the process was taken for provincialization of the school, and since 2009-10, the school applied for provincialization, then in all dias forms, my name is visible. And in the first dias form, the name of the private respondent was not at all there. And in later years, all of a sudden, her name has been there. And the process, how she made the second assistant teacher, and I was discarded from the service, was completely injustice to me, your lordship. So this was the case, your lordship, and I served for so many years. I gave my valuable time, your lordship. I gave my entire youth life, getting nothing from this school. Now I cannot apply for any other job, your lordship. My age has passed, your lordship. And all my sacrifice, all my work, has been discarded, your lordship. This was complete injustice, your lordship, and therefore,
Yes.
your lordship, the prayer is that, your lordship, that now government has changed so many acts regarding school, your lordship. If I can get some relief, I can get justice, your lordship. That is my prayer, your lordship.
This writ appeal is filed by the appellant being agreed with the order dated 8/12/2015, passed by the learned single judge in writ petition number 2595, public 2013. The writ petition filed by the appellant challenging the provincialization of respondent number 6 has been dismissed. Full stop. The case of the petitioner before the, in the writ petition, case of the appellant in the writ petition was that he was appointed as first assistant teacher number 13 in Behu Pukhuri LP school on 6/1/2005. So it is contended by the appellant that his name appeared as first assistant teacher in district information system for education in bracket DISC bracket close for academic year 2009-10, 2010-11 and 2011-12, and the name of the respondent number 6 appeared as special assistant teacher,
Second assistant.
second assistant teacher, showing her date of joining as 2007 instead of 2011 when she actually joined. Full stop. The appellant has contended before the learned single judge that though the appointment of the appellant as assistant teacher was prior to the respondent number 6, but the respondents have illegally provincialized her services in place of the appellant. Full stop. The learned single judge, after taking into consideration the documents placed on record along with the recommendation by the appellant, has recorded finding in para number 13. Full stop. The para number 13 of the impugned order reads as under. Full stop. The learned single judge has concluded that the appellant has failed to substantiate her claim that she was his claim that he was appointed as first assistant teacher in the year 2000, first assistant teacher on 6/1/2005. Full stop. The learned single judge has also observed that the
Petitioners became eligible to did not dispute of that.
the learned single judge has also observed that at the in the year 2005, the appellant was not having the qualification for appointment as a teacher in the venture school, and it is the admitted case of the appellant that she has that he has not passed HSLC examination, which is the requisite qualification for appointment on the post of assistant teacher. The learned single judge has concluded that the appellant was became eligible to be appointed as assistant teacher only in 2007, and therefore the claim of her, the claim of him for for giving precedence over the claim of the respondent number 6 is not tenable. Stop. Having heard the learned counsel for the parties and after carefully scrutinizing the record available on record, we don't find any illegality in the impugned order passed by the learned single judge. Hence, no case for interference is made out. Writ appeal is dismissed.
Yeah, that is not possible disclosed, it will be open for the respondent.
It would be open for the appellant to claim provincialization of her, of his services in accordance with law. Holding the field. Holding the field. In accordance with law, holding the field. Treating the appointment of the appellant as assistant teacher in the year 2007.
Item 4 and 5.
Right, please, loss. These two appeals are filed by the state, my lord, against the judgment order passed by the on single judge, my lord, directing that the land acquisition should be determined according to the 2013 Act. And what has happened in the meantime, in item number 4, response number 1 has expired. We'll have to substitute by filing an application for substitution. I'm praying for my 3 weeks time to file a substitute petition, madam.
Okay. When concept of the appellant has submitted that during the pendency of the present appeal, the respondent number 4 in writ appeal number,
Response number 1, madam.
respondent number 1 in writ appeal number 185 of the 2000, you have already moved an application.
No, madam, I'm filing it. I'm in a couple of application
Writ appeal
stage.
number 208,
185, madam.
185.
My lord.
2017 has expired and therefore his legal representatives are required to be taken on record. It takes some time to move appropriate application for bringing the legal representatives of the respondent number 1 on record. Time frame for his granted. Let's start 3 weeks.
Item number 7.
My lord, this is regarding substandard supply of substandard medicine, my lord, to the government outlets, my lord, medical outlets. For which, my lord, infants and mother died. My lord, there are several incidents in Assam also, my lord. It has been reported in newspaper. And in the previous order, my lord,
Mr. Gogoi, standing counsel, you have filed the affidavit.
Yes.
yes, my lord. They have filed, my lord, on 5/3/2024. Only during that period, my lord, 6 months, type of measures they have taken, the government has taken to curb the problem, my lord. But this is nothing but the measures means, my lord, whatever the documents they have given annexed with the affidavit, my lord, these are all dissolution test, my lord.
These are all
Dissolution test, my lord. That means the tablet, my lord, the product is not dissolved, my lord. They have tested it and given the report. That means, my lord, that past 6 months, more than 6 months, my lord, same thing is going on, my lord. Misbranded, substandard medicines, my lord, supplied to government, my lord. And here, my lord, the procurement is made by the government, my lord, by the respondents. And respondents are all government, my lord. And government, when they procure, my lord, it is public money, my lord.
Ma'am, have you filed any response to this affidavit?
My lord, the latest affidavit, my lord, we have nothing to say, my lord, because these are the tests, my lord, given to the, submitted by the Planet Friend, my lord.
So what mechanism you are
Because-
suggesting?
We have
for
very
this,
simple prayer, my lord,
Yeah,
that it should be carved in the beginning, my lord. That means the batch-wise medicine, maybe drugs or medicine, maybe, my lord, checked before the procurement, my lord.
before the procurement.
Yes.
means When the procurement would, if before the procurement, if they are going to check it, then how they'll procure
Before
it?
supply in my lord to the different outlets, before accepting the batches, my lord, the medicines, the government should take measures to stop the, my lord, to get the certificates, my lord. There's this-
Suppose they are issuing NIT.
Yes, my lord.
And if they are, in that NIT, they are giving the prescription that such tablets or such combination chemical, this combination tablets are to be supplied. And if they supply such tablets by a authorized manufacturer,
Yes, my lord.
so what is the, and how can they, each and every, I mean
Medicine.
to say that tablet can be checked?
No, my lord, not each and every tablets, my lord. The batch wise, my lord, the boxes, the batches, my lord. That should be checked, my lord. And one more thing, my lord, there's a government institution, my lord, where the certificate, clearance certificate is given. Drugs, what? There's a drug testing laboratories, my lord, in Assam. My lord, in spite of my lord taking, my lord, all the reports, my lord, given by the,
What is the mechanism of procuring these drugs?
My lord,
What is the mechanism you are following? The state government is
by way
following?
of a tender, my lord, these parties are selected, my lord, suppliers are selected. And my lord, from time to time, on need basis, supply orders are issued to them. Now, my lord, while supplying the drugs, my lord, they are supposed to, my lord, furnish a certificate from a national testing laboratory. Only then, my lord, they are allowed to be supplied to the various district warehouses. And in the district warehouses, our state authorities, those drug inspectors, they used to make the, my lord, random checking and all that. And whenever it is found, my lord, their goods are directed to be replaced. And necessary penal action as per the contract act is taken against the supplier.
So they are required to give a certificate of national laboratory.
Yes, NABL accredited laboratories, my lord. Every supplier.
Yes, Dr. Reddy, what is the basis of this PIL, if we might ask you? You have referred to the incident of Borpeta. Is there anything to show that it happened because the drugs were spurious?
Yes, my lord, the report is there, my lord.
What is the report?
And also, my lord, there is a planning commission's report, my lord, at page 18, my lord, annexer 1, my lord,
Page 18.
18, my lord.
This is a mortality rate.
My lord.
This is the
Yes,
infant
my lord.
mortality rate.
Yes,
There's
yes, my
no
lord.
doubt about that. But you
But it is-
claim that the drugs which are supplied by the government hospitals
Yes,
are
ma'am.
not up to standard.
Yes, my lord.
To substantiate that claim, what is the material?
Yes, my lord, there is. My lord, we had, we have obtained information, my lord,
Yeah.
through RTI, my lord, and this has been also annexed.
So which is that information? Please?
Yes, ma'am. My lord, page 28, my lord,
Yes.
annexer 5, my lord. My lord, here at reply to query number 5, my lord. The last line of the first para, my lord. The regional drug testing laboratory, RDTL, under GOL for further testing. During last year, RDTL have reported few drugs not of standard quality in terms of physical appearance like hardness, breakage, etc. during storage and transportation. And the last one, my lord. Last one, my lord. The same para. But their test samples were cleared from other government approved NABL laboratory. Then also NHM Assam as well as drug controller. Assam has immediately informed to stop all such distribution and consumption of these batches observed not of standard quality as per RDTL report and issue show cause. They themselves have said, my lord. And also,
Admitting,
my lord.
and this reply to this query number 5D,
Yes, my lord.
batch-wise testing report from has been collected before allowing the supply of districts.
Yes.
Without enable report supply, no batch has been supplied by any districts ever.
My lord, if so, my lord, if so, my lord, why now also, my lord, within 6 months, before 6 months, the same substandard medicines are supplied, my lord. If they have taken clearance, my
Regularly,
lord,
if the substandard medicines are being supplied, they
My-
are regularly checking it. What else?
my lord, we have also filed one additional affidavit, my lord,
Yeah,
and there also report has been annexed.
where is that?
It must be there, my lord. It must be page number. No. Which date?
17.
My lord, 22nd March 2018, you have filed an affidavit in reply, my lord. And page number 71, my lord. And at page 79 of our affidavits, my lord, annexer 12,
Page?
79, my lord.
Yeah.
So these are the report, my lord. On the last line, in the opinion of undersigned, the sample referred to above is not of standard quality. And this is given by a government analyst, my lord. All reports have been annexed, my lord. And these are issued by government person, my lord.
Madam, so from these reports where it is reflected that all the drugs which are being supplied are substandard. Yes, certainly. You have referred to some report also where they said that 10% of the drugs are substandard. That is
My
right.
lord, even 1% is substandard, my lord. That could also, my lord.
10% of the government supply chain services health ministry survey. Yes, it is there, but they are taking care of that.
My lord, it should be, my lord, this is a, my lord, the issue of life, my lord. It relates to life and death, my lord.
But
Infants are, my lord, they are, my lord, affected, and mothers, and that too poor people, my lord. Government hospitals, my lord, who go? My lord, only that kind of people go, my lord.
we
So
understand.
they can be also
we
given
understand,
safeguard,
madam,
my
but
lord.
what suggestions now you?
My lord, only, my lord, proper certificate may be given, my lord, after procurement of the drugs, my lord. Only that much, my lord. And then it could be checked, my lord.
They have already mentioned in para number 22, batch-wise testing report from the government approval, NAB lab has been collected before allowing supply to districts.
My lord, they,
Without NABL report, no batch has been supplied to any districts ever.
my lord, if that is really, my lord, this is the true facts, my lord, then why data causing, my lord? Data caused, my lord.
They,
Death, my lord. How the patients are, my lord, the mother and infants are affected, my lord. Then why detected, my lord? Substandard medicines are detected as per the reports of my affidavit, my lord. Not only in one medicine, my lord. There are several medicine they have mentioned, my lord, in all the reports in the as annexed with the affidavit, my lord. So only thing is that, my lord, that may be properly before supplied to the government outlets, my lord, and the hospitals, my lord. It may be again, my lord, checked properly. That much only we want, my lord, for the sake of public, my lord, poor public. Only that much. The government can take proper measures. We are not blaming government also, but the suppliers and, my lord, they obtain certificates, my lord. Maybe, my lord, forcibly they do it, or maybe, my lord, they manipulate to get it, my lord.
yes. Yes, Mr.
Well, so far as the allegation of the petitioner is concerned, from the affidavit is apparent from the various documents annexed in the PI, as well as the affidavit that we have filed. That, my lord, time to time, the, my lord, verification has been done. That's why, my lord, all these, my lord, spurious drugs has been detected. Because we are doing the job. Otherwise, my lord, whatever is supplied with that certificate, my lord, if we distribute and, my lord, if it is prescribed to the patients, my lord, the thing would have been different, my lord. And there is not a single instance, my lord, or any evidence to show that, my lord, by consuming these particular drugs, some, my lord, that has been caused. It is the apprehension of the petitioner, my lord. There is nothing on record to show that, my lord, this infant death and all has occurred due to these spurious drugs. It has been detected, and, my lord, we have been directed to supply fresh. We have stated in our affidavit. And if any suggestion is given, definitely the state will, my lord, act upon it, my lord.
My lord, even the recent affidavit, my lord, the annexes they have made, my lord, this is the report of different medicines, my lord. My lord, kindly see, my lord, affidavit dated 5/3/2024, my lord,
Yes.
filed by the government. My lord, they are page 239.
Yes.
My lord, here, everywhere, my lord, dissolved test fail. That means dissolved test means, my lord, tablet is not dissolved. If it is not dissolved, that means there is no proper components of the tablet, my lord. And if it is not dissolved and somebody consumes, my lord, anybody goes to the government hospital, that means it will not give any effect, my lord. It will not go through the blood circulation. So what is the harm, my lord, if government is directed, my lord, to take proper measurements so that the lives will be saved, my lord,
No problem.
of lives, my lord.
Order is the argument, sir, order is the.
Obliged.
For hearing, item 8.
May I please, Lordship? Lordship, this is Central Excise Appeal. I am challenging an order of the Central Excise Tribunal at Calcutta. Lordship will peruse order dated 28/1/19 in this appeal, Lordship. The substantial questions was framed. If I may please read, Lordship. Question number 1. When the plant and machinery purchased by an assessor.
You are reading from which page?
Lordship, second page. The substantial questions have been framed, bottom side. Order dated 28/1/2019, Lordship.
Yeah.
Lordship, after discussing the facts, 3 questions have been framed by this honorable court. When the plant and machinery purchased by an assessee in one financial year without appropriating them, oblique installing them for the use in the manufacture of finished goods by an eligible unit, whether the assessee is entitled to avail SANVAT credit in respect thereof, treating the same as capital goods under Rule 4 of SANVAT credit rules. So, Lordship, if I may just brief to refresh the memory of this court regarding the Central Excise, Lordship, SANVAT credit is paid when input services or capital goods are purchased by the assessee from the supplier. Some tax is paid to them. That tax we claim as input. And when we sell off the finished goods.
Mr. Saraf, see, second question, is there a grammatical mistake? Please read it.
If the answer to the question number 1 is in negative, whether the said assessee is not entitled to avail the SANVAT credit only when the said plant and machinery is used in the factory of the manufacturer of the finished goods in order to qualify as capital goods under Rule 2 of the SANVAT credit rule 2004. Seems good, Lordship.
Okay.
Seems good.
Whether it is not entitled to.
SEC is not entitled or entitled to avail.
So it can be, if the answer is in the right manner, it can go both ways, Lordship. If your Lordship holds he is entitled, then it is answered suitably.
Now, if the question is wrong, the answer is likely to be wrong. You take that risk.
Lordship, I pray for correction of that question.
No, it's up to you.
I would like to continue,
But
Lordship.
the answer will be to the question only.
Lordship.
Not to new. He is entitled. That can be.
It may be corrected, Lordship. It may be taken up on the. That word not can be removed, Lordship. I pray for the same.
The intention of the appellant is a question of law.
Yes, Lordship. Because the intention determines the extended period of limitation. Because if there is a
How
question.
can the intent of a particular person be a question of law?
No, Lordship, what I'm trying to say is, extended period of limitation comes into effect only when there is a fraudulent intention. If it is a dispute of a question of law, how can that be invoked? That is the question, Lordship. But my contention is, they say that you should have taken Sandwich credit. If I may please continue, Lordship. So, Lordship, Sandwich credit, when the finished goods are sold off in the market, I have to pay some taxes to the government. So I claim that input taxes which I have paid to the supplier, and the balance I pay to the state exchequer. In this manner, I claim Sandwich credit, Lordship. Now, Northeast is area-based exemption, Lordship. All the SSCs have exemption as regards their industrial units. For that exemption, what happens is, I claim the input, I pay off the taxes, I file a return to the assessing officer that please give it back to me. So I get the refund after payment of taxes, because area-based exemption is applicable in Northeast, Lordship. Now, the point of dispute in this case, Lordship, I have purchased some capital goods in 2007-8. They say that if you have purchased it in 2007-8, you ought to have taken the Sandwich credit in 2007-8 itself. I have taken it in 2010-11 when the goods were put to use as capital goods. This is the point of dispute in this particular case, Lordship. Now I can proceed to the impugn order, Lordship. Page 38 of the appeal petition, Lordship. Order starts at page 39, Lordship. If I may please read, Lordship. The dispute in order in appeal is the recovery of refund of 15,95,000 during the year 2007-8 and 8-9 that was found to have been erroneously sanctioned, and disallowance of Sandwich credit of 22,93,920 on capital goods held to have been incorrectly availed. So, Lordship, there are two demands in this order. Because they say that 2007-8 you did not claim the Sandwich credit, you paid more taxes. You paid more taxes, you sought more refund. So 15 lakhs or odd was given as erroneous refund to you. And you claimed the Sandwich credit in 2010-11. So that credit you could not have taken in 10-11, you should have taken in 7-8. So that they need to recover from you. This is their allegation, Lordship. If I may please proceed, Lordship. Allegedly, the appellant procured capital goods from Inox Air Products Limited, but retained the same in their factory without installation to obtain a higher refund under notification number so-and-so. That is the exemption notification, Lordship. It was held that deferment of availment of Sandwich credit till utilization enabled payment of duties of central excise by cash, which was then claimed as refund that was limited under the said notification to the amount of duty paid without recourse to Sandwich credit, which I have already explained to your Lordship. Paragraph 3. Learned Counsel for Appellant contends that the definition of capital goods in Rule 2A of Sandwich Credit Rules 2004 mandates the deployment and usage of such goods within the factory. It is his further contention that Sandwich credit can be availed within a prescribed period after the capital goods are installed, and that the facts and circumstances were known to the jurisdictional authorities. Reliance was placed by them on the decision of the Supreme Court decision typo. This should be MP High Court, Lordship. Learned authorized representative places reliance on the decision of Sun Pharmaceuticals, Delhi Tribunal. Having heard the rival submissions, we take note that the issue relates to the point at which Sandwich credit should have been availed by the appellant. It is not in dispute that the goods have been procured well in advance of installation, and that Sandwich credit was taken subsequent to assembling
and against the same invoices on which goods were procured. From this, it is clear that capital goods were delivered by suppliers and received by them in their factory during 2007-8. While usage within the factory may well be an expression employed and adduced in the definition argued by the learned counsel, it is Rule 3 of Senway Credit Rules that authorizes availment of credit, and that too specifically upon receipt in the factory. Accordingly, we hold that the eligibility for Senway credit arose in 2007-8, and these being capital goods, credit should have been availed in 2007-8 and 8-9. Consequently, the refund amount claimed during these 2 years was in excess of their entitlement, and the recovery thereof cannot be faulted. The claim of the appellant that these facts were known to the jurisdictional authority does not impress. The refund claim did not contain any declaration of procurement of capital goods without availment of Senway credit. As far as the subsequent availment of Senway credit is concerned, without a finding of ineligibility for the amount claimed, and in view of recovery of refund that was in excess of such deferred credit, we hold that entitlement to Senway credit is not deniable. Recovery of that amount is not correct. Accordingly, the appeal of appellant is allowed to the extent of setting aside the demand of 22 lakhs or like, while upholding the recovery of 15,95,000 or like.
So first, what as per this order, you were supposed to claim Senway credit in 2007 and 8 and not in the subsequent years. So you claimed first in the, claimed in the subsequent years.
10-11.
10-11. And what about this 22 lakhs 93,000?
I claimed 22 lakhs in 10-11. They say that since you have paid those taxes to supplier, and since there is no finding of ineligibility that you have paid that taxes, we will not recover that. That is okay. But since 2007, if you would have claimed the Senway credit, you would have got lesser refund. So we will recover that refund. They say so.
Now show us that you can claim this Senway this credit even in the subsequent years.
Lordship. So having seen the impugned order, Lordship, department's allegation is 7-8, I should have claimed the Senway credit. I say that 10-11, because there are two rules which substantiate both propositions. Senway credit rules 2004 has to be looked into, Lordship.
Yes.
If I may please read, Lordship, first page itself. Senway credit rules 2004. Rule 2 defines capital goods, Lordship. My Senway credit is related to taxes paid on procurement of capital goods. Capital goods means the following goods, namely, there are 8 categories. The category is not in dispute, Lordship.
Fine.
I lay emphasis on the word used. The definition says only if those goods are used. There are 2 in the factory of the manufacturer of the final product.
Where they are reading?
Lordship, after the 8 categories of the goods, Rule
category.
2A.
In the factory, the manufacturer of the final does not include any equipment applied so and so.
Yes, Lordship. And there is second, which
1A.
1A. I would lay emphasis on 1. That these definitions says, Lordship, capital goods means those goods which are used in the factory of the manufacturer of the final products. That is my submission, Lordship. That without it being used, it does not become capital goods. It does not acquire the nature character of capital goods. And until and unless it acquires the nature character of capital goods, I cannot claim Senway credit on those goods, terming it as capital goods.
These falling under this and so, but including dumpers and trippers used.
The emphasis is on the word use, Lordship, again and again. Without use, they cannot allow me to claim it as capital goods. That is the rule which I rely upon, Lordship. Now, there is a rule which they rely upon. So, Lordship, that will be Rule 4, page 8 of 22 of the Senway credit rules. Page 8, bottom side, it says Rule 4.
Yes.
conditions for allowing Senvet credit. Next page, Lordship, 4(2)A will be relevant.
You read this for
Lordship, it is regarding inputs, not capital.
the
goods. The
Senvet credit in respect of inputs may be taken immediately on receipt of the inputs in the factory. It is not in the capital goods.
This is not capital goods, Lordship. This is inputs. The 2A is regarding capital goods, Lordship. Next page, first line,
2A,
Lordship.
yes.
The Senvet credit in respect of capital goods received in a factory or in the premises of the provider of the output service or outside the factory of the manufacturer of the final products for generation of electricity for captive use within the factory at any point of time in a given financial year shall be taken only for an amount not exceeding 50% of the duty paid on such capital goods in the same financial year. So Lordship, they say that the word used here is Senvet credit in respect of capital goods received in a factory. They say that you have received it in 2007-8. So you take the credit in 2007-8.
So that means something. Because the Senvet credit respect of capital you received in a factory or in the premises of provider or so and so at any point of time in a given financial year shall be taken here for an amount not exceeding 50% of the duty paid on such capital in the same financial year.
Lordship.
That
And they have set a cap for an amount not exceeding 50%. So they don't say that you have to take 50%, you cannot exceed 50%.
in the
You
same
can take-
financial year.
Yes, you can take below that, you cannot exceed 50%. Because the word used is not exceeding 50%. So anyways, that is not the main point of dispute, Lordship. The Lordship has to take an opinion whether the emphasis has to be laid on the word use or the primary emphasis has to be taken on the word receive. Because there has been various cases, Lordship, all through this country, in which if I procure some goods, but I don't use it in manufacture,
Proviso, is there any, this proviso to rule 2A? Provided that when the Senvet credit in respect of capital goods shall be allowed for the whole amount of the duty paid on such capital goods in the same financial year, if such capital goods are cleared as such in the same financial year.
that is the idea, Lordship. The capital goods, if I received in 2007-8, if I sell it off in 2007-8 itself and without using it for manufacture, in that case, I can use entire credit 100%. Because that thing came, that thing went away. So whatever the balance of taxes I will pay after claiming the input. On that idea, this proviso has been drafted, Lordship. Now, on the same idea, Lordship, when they talk about Senvet credit in respect of capital goods received in a factory, until and unless those goods are used as capital goods and they deliver a finished products and those are sold in the market, bringing taxes to the exchequer, they will not allow me to claim the Senvet credit. That goods have to acquire the nature and character of capital goods because then it directly links with the finished product produced by that capital goods. But in that respect, the impugned order says that,
Mr. Saraf,
Lordship,
see, there are two provisions of the rules of 2004 which are into play.
Lordship,
One is definition in Rule 2.
Lordship,
That provision deals with definition of what is capital goods.
Lordship.
Correct. Rule 4 deals with the manner in which and the conditions of allowing Senvet credit. Now, the dispute in this proceeding is not whether the goods you have brought is capital goods or not.
Lordship,
The dispute is whether you are entitled to Senvet credit.
Lordship,
So, in resolving that dispute,
Lordship.
obviously Rule 4 will have a
It will have
paramount
a say.
application.
Lordship,
If that is correct,
yes.
what is there to be decided here?
Lordship, what is to be decided is Rule 4(2)A only allows to claim Senvet credit in the same financial year for capital goods. Whether that goods acquired the nature and character of capital goods is what is to be decided.
Even if you don't use it, it
Lordship.
still remains capital goods.
No, Lordship, there are several cases, they differ. There are several cases, Lordship. I will show to your Lordship. If I may resolve that query in the first place, Lordship, after that I may proceed. These confusions, Lordship, these confusions arise, there is a reason behind. In those areas where area-based exemption is not available, in those areas, they say that you have not used it, we will not allow to take credit. But in our area, there is an area-based exemption. So they say that you take credit first. That is the particular reason why this confusion arises, Lordship. Now, if I may first point out the case of Madras Cement, Lordship, 2010 Supreme Court, paragraph 11 and 12 will be relevant, Lordship. If I may please read, Lordship. As indicated, the short point involved in these appeals relates to the eligibility of the SSE for moderate credit on certain capital goods which were said to have been used as components, spares, and accessories in the manufacturing process of the appellant for the period in question. In order to avail of moderate/Sandwich credit, an SSE has to satisfy the assessing authority that the capital goods in the form of components, spares, and accessories had been utilized during the process of manufacture of the finished product. So it was laid down that a particular condition will be that if it has been utilized, only then the Sandwich credit can be availed, Lordship. Subsequently, in 2013, placing reliance on this judgment, Lordship, again, paragraph 23 and 24 KCP Limited, Lordship. In our opinion, the above stated reason is quite sufficient for denying any moderate credit to the appellant. While dealing with a similar issue, the court had observed in paragraph 15 of Madras Cement, which your Lordship has already read. Looking to the above legal position, in our view, the impugned orders passed by the tribunal cannot be said to be incorrect. It is also not in dispute that the appellant had purchased some machinery from others, and such machinery had not even been unpacked by it, and in the exact condition it had been transported along with the machinery manufactured by it to Vietnam. Thus, the appellant did not use the purchased machinery in its premises or in its factory, and therefore necessary condition incorporated in the rules for availing credit of the moderate had not been complied with. To avail the moderate credit, the input on which excise duty is paid must be used in the manufacture of the final product in the factory of the SSE. The machinery purchased by the appellant had not even been tested or was not even unwrapped in the factory of the appellant. In case of such an admitted fact, it cannot be said that the machinery so purchased from others was used by the appellant in the manufacture of the sugar plant. He had only acted as a trader or as an exporter in relation to the machinery purchased by it, which had been exported and used for setting up sugar plant. It cannot be said to have manufactured that plant in its factory. So, Lordship, it was a similar case in which machineries were procured. It was not unwrapped. In that case, they have denied Sandwich credit to the SSE.
So the year of use and year of receiving,
Lordship.
these two have to be same according to them.
Lordship.
All right. If you use it, then you get the full Sandwich credit.
Lordship.
If you dispose it off,
Lordship.
then the difference of the duty is what you get it.
Lordship. If I dispose it of, entire credit I can avail in the first year itself.
So therefore, there is some flexibility on the count of usage. You may or may not use it.
Lordship.
But insofar as the receipt, year of receipt is concerned,
Lordship.
that is a fixed quantity.
Lordship.
That's a rigid quantity.
Lordship.
And the rules relate to the year of receipt, apparently. Is that correct?
Lordship, what is received will be significant, whether it was some goods or it was capital goods, in my humble submission. Receipt, your Lordship has very well pointed out, but what was received? That would be significant, Lordship. So I also have another two Supreme Court judgments, Lordship. Honorable Supreme Court.
Mod vet is the state component, mod vet, modified value added tax, is it not?
Before the Senate regime, it was mod vet.
Mod vet.
Lordship, Supreme Court had propounded a user test, which your Lordship will find. Paragraph, Commissioner of Central Excise Jaipur versus Rajasthan Spinning 2010, Lordship. Paragraph 12 will be relevant.
Which decision?
Rajasthan Spinning and Weaving Mills, Lordship, 2010 Supreme Court.
Paragraph?
Paragraph 12 will be relevant, Lordship. It talks about user test.
Yes.
2010 255 ELT 481. If I may please read, Lordship. Inter alia observing that capital goods can be machines, machinery, plant, equipment, apparatus, tools, or appliances. If any of these goods is used for producing or processing of any goods, or for bringing about any change in the substance for the manufacture of final product. Although this view was expressed in the light of the aforesaid definition of the capital goods in the state rule, which was a similar definition, Lordship, which is not there in Rule 57Q, as applicable in the instant case, yet the user test evolved in the judgment, which is required to be satisfied to find out whether or not particular goods could be said to be capital goods, would apply on all fours to the facts of the present case. In fact, in paragraph 6 of the said judgment, the court noted the stand of the learned additional Solicitor General appearing for the revenue to the effect that the question whether an item falls within the purview of capital goods would depend upon the user it is put to. Subsequently, Lordship, there is a Commissioner of Central Excise versus Jawahar Mills 2001 Supreme Court. Paragraph 4 and 6 will be relevant, Lordship. I'm reading paragraph 4, Lordship.
Jawahar Mills is not subsequent. It is a prior decision.
It is a prior decision, Lordship. Based on this, Jawahar Mills, the 2010 Supreme Court was the judgment, user test was evolved. But when your Lordship goes through, your Lordship view will strengthen that the user will be important, Lordship. Paragraph 4 says, Lordship, the aforesaid definition of capital goods is very wide. Capital goods can be machines, equipments, machineries, plant, apparatus, tools, or appliances. Any of these goods, if used for producing or processing of any goods for bringing about any change in the substance of the manufacture of final product would be capital goods and therefore qualify for availing mod vet credit per clause B. In the last 5 lines, Lordship, the goods enumerated in clause C did not be used for producing the final product or used in the process of any goods for the manufacture of final products or used for bringing about any change. And the only requirement is that the same should be used in the factory of the manufacturer. Thus, it can be seen that the language used in the explanation is very liberal. Subsequently, paragraph 6, Lordship, the contention of the learned additional Solicitor General that the aforesaid decision and other decisions referred by the tribunal in the impugned order were cases involving sales tax and income tax, and therefore the tribunal should not have relied on those decisions, is without any substance, because the real question is that of the principle laid down by a decision. In view of the liberal language of the provision, Mr. Rohtagi fairly and very rightly did not seriously dispute that if any of the items enumerated in explanation 1A is used for any purpose mentioned therein for the manufacture of final product, it would satisfy the test of capital goods. The main contention, however, is that the question whether an item falls within the definition of capital goods would depend upon the user it is put to. The submission is that parts of the items in respect whereof availing mod vet credit has been allowed could not be treated as capital goods, as the manufacturer could not establish that the entire item was used in manufacture of final products. To illustrate this, Mr. Rohtagi submitted that part of a cable may go into the machine used by the manufacturer and thus may qualify the requirement of clause 1A. And at the same time, another part of the cable which is used only for lights and fans would not so qualify. We have no difficulty in accepting the contention of the learned additional Solicitor General that under these circumstances, user will determine whether an item qualifies or not the requirement of clause 1. So, Lordship, it is not only an expression employed in the legislation, as has been mentioned in the impugned order, because it carries substantial weight. And there has been a lot of litigation on whether a product has been used in a particular manner or not. And the impugned order says that it is only an expression in Rule 2, and it might not be significant in deciding the case. Now, Lordship will come back to the facts of the case, Lordship. There are 3 orders by the courts below, contrary findings of all the courts below. The original authority first proposed that I will recover the sandwich credit also, I will recover the erroneous refund also. But subsequently, on coming to know about the facts of the case, he was satisfied, he dropped both the demands, the original authority. When the order was subsequently reviewed by the department and went into appeal, the appeal commissioner again set aside the order and raised both the demands. Now, when it came to tribunal by the appellant, one demand was set aside, another demand was upheld. Now, on what ground that demand was upheld, Lordship? I read that line again. From this, it is clear that capital goods were delivered by the suppliers and received by them in their factory during 2007-8, while usage within the factory may well be an expression employed and adduced in the definition argued by the learned counsel. It is Rule 3, which is Rule 4, which Lordship has just read, Sandwich credit rules that authorizes availment of credit. So only based on this line, they are upholding the demand against me that the usage within the factory may well be an expression employed. So Lordship has already seen it is not only an expression employed, there has been a lot of litigation on it. So once I avail it, then they say that why you have availed it without use? Once I have not availed it, then they say, no, it is exemption area, you gave it back. Now, reason for claiming in 2010-11 Lordship, the products were lying in the factory from 2007-8 to 10-11 unused. It was decided in 10-11 that those will be used, we will not sell it off. It was available at very low prices. We purchased it instantly, but we could not decide whether we will sell it off or we will use it. These facts are undisputed. These have not been disputed by the department. As soon as we have used it in the year in which it was commissioned, which has been mentioned in the order, we have taken the sandwich credit. This is our case, Lordship.
With regard to the facts, probably I may not the facts. I want to again place page 40, paragraph 5 of the sets order. Yes, having heard the rival submission, we take note that the issue relates to the point at which the sandwich credit should have been availed by the appellant. It is not in dispute that the goods have been procured well in advance of installation and the sandwich credit was taken subsequent to assembling and against the same invoices on which the goods were procured. From this, it is clear that the capital goods were delivered by the suppliers and received by them in their factory during 2007-8, while usage within the factory may be well an expression employed and reduced in definition argued by the learned counsel. It is Rule 3 of the Sandwich Credit Rule 2004 that authorizes availment of the sandwich credit that too specifically upon receipt in the factory. Accordingly, we hold that the eligibility for sandwich credit arose in 2007 and 8, and these being capital goods, credit should have been availed in 2007-8 and 2008 and 9. Consequently, the refund rupees of 15,95,000 so and so claimed during these 2 years was in excess of their entitlement and recovery. There cannot be faulted. Lordship, Rule 4, my land defense is placed. Lordship is seen. It is said that it should be available in same financial year. Lordship, I want to place to notification. Lordship, against that the demand which was rejected by the same, we prepared appeal before the record is also before the Lordship. We withdraw that appeal on the ground of monetary limit because the amount was less than 50 lakhs. So we withdraw the appeal. Lordship, in that appeal, page 27 and 29, we have placed two notification.
Which appeal?
Lordship, there is an appeal prepared by the department against the demand which was dropped by the learned CSET. But we withdraw the appeal on the ground of monetary limit. The record is before a Lordship. Lordship, I want to place one. Yes, sir. Yeah, look at the record. Lordship, page 27. It is a circular dated 4th of June 2009. Page 27, Lord.
Here, no page 47. it's only
27, Lord. 27, Lord.
27.
Lord.
Yes.
Is a circular dated 4th of June 2009.
Yeah.
Subject area-based exemption clarification regarding phrase whole of the sandwich credit available regarding. A reference has been received from Chief Commissioner of Central Excise, Chandigarh, in respect of manufacturers located in jurisdiction of Jammu Kashmir Commissionerate, availing the area-based exemption notification 56 of 2002 dated 14/11/2002. It was mentioned that as per para 1A of the notification, the exemption is available subject to the condition that the manufacturer first utilize the whole sandwich credit available on the last day of 2 months for the payment of duty on goods cleared during that month and pays only the balance amount in case. However, in few cases, it was noticed that the manufacturer did not avail credit on few invoices and consequently they paid the higher amount in case. At the time of sanction of the relief, this aspect was noticed. This practice followed so far was to deduct the amount of said non-avail credit from the amount to be paid as refund. However, if such cases were noticed during the audit, the practice was to recover amount of said credit along with interest, but subsequently a view was taken that the condition of the first utilizing the whole amount of credit before payment in case the subsequent condition, hence any non-compliance thereof would mean violation of condition of notification resulting in non-entitlement of the benefit of notification. Paragraph 2. The matter has been examined in consultation with TRU since sandwich credit rules do not prescribe a time limit for carrying forward the sandwich credit. A manufacturer can retain the unutilized credit in books indefinitely till the end of tax holiday and utilize the same for payment of duty thereafter resulting in manufacturing getting a much larger benefit than envisaged. It was to provide this loophole from being exploited that the notification was modified, prescribing full utilization of sandwich credit available before making any payment in case. Next, the function of prescribing the said condition has been explained in para 2 above. Therefore, rejection of the entire refunds claim in such situation was not warranted or intended. Therefore, it has been decided that in case where the sandwich credit is utilized on few invoices, the practice followed so far, which is given in para 1 may continue. However, in such cases, the sandwich credit should be got reversed. Clarification is issued only with respect to peculiar facts of the case, should not be used for interpretation of any other notification. Field formation was also advised that the units where exemption period is coming to an end. Refund application of these units may be verified carefully to ensure all the sandwich credit has remained to be taken and verified by them. All the pending refund claims should be decided and disposed of in light of the above notification. And then Lordship,
This supports his case.
no Lordship, thereafter Lordship, page 29. Because Lordship, he has procured the machinery in 2007 and he didn't utilize. And as per sandwich credit, he has to utilize in the same year. And Lordship, page 29.
No, Mr. Kyle, the notification you just read
Lordship,
says that he can avail the credit
on the same.
by carrying it forward till the end of the period of tax holidays.
That is here, but Lordship, here in this case, he has procured the machinery in 2007 and 8.
Correct.
He kept it, didn't utilize Lordship and avail the,
But 2010-11, that tax holiday is over or was that
that was not over. Because they are entitled to for 10 years tax holidays. Then Lordship, page 29.
Yeah.
This is a notification dated 11th of June 2012. Non-utilization of whole Sandpit credit avail at to any unit availing area-based exemption. I am directed to refer your letter dated so and so 14/2/2012, wherein it has been suggested to have a relook at the board's clarification dated 4th June 2009, issued from finance so and so on the above subject. In your aforesaid letter, it has been inter alia has been suggested that when an SEC has not taken credit available to him and consequently has not utilized it for payment of duty, the relevant invoices should be defaced to ensure that the credit is not taken on them subsequently. The matter has been examined. At the present, there is no provision of defacement of invoices prescribed in the rule. Moreover, prescribing this procedure to address such unusual and rare situation may not be practical. Accordingly, whenever it comes to the notice that an SSC has not taken Sandpit credit of the duty paid on some invoices, he may be directed to take the Sandpit credit to bring the situation at par with the situation where Sandpit credit has been taken but not utilized during the currency of the area-based exemption. The aforesaid board clarification dated 4 June 2019 will then become applicable to such SSC. The SSC amounts to refund the extent Sandpit credit was not taken should either be deduct from the refund payable to the SSC or recovered along with interest as the case may be. Further, as mentioned in para 3 of the board clarification dated so and so, credit should be got reversed. So this is a clarification Lordship,
clarification of what?
regarding non-availment of the Sandpit credit during the financial year when he is procured.
The financial year, where is the word, even word this during the financial year?
Lordship,
This
so
notification.
the word is not there, but Lordship, the intention of the department is very clear. When they have not availed the Sandpit credit during that financial year, that can be recovered.
This earlier notification says they can very well claim in the subsequent years. Now this clarification is nothing. What it appears that they cannot claim after the tax holiday is over.
No,
This is what intention of this notification, what we understand. At least I understand that.
That's it. This notification is on the point.
Lordship, this is the.
And it says, as long as the tax holiday is in currency, the SSC can avail it.
But Lordship, the rules and when we read this clarification along with the rule 4, it is clarified.
What about this clarification, earlier clarification, 4 June?
Yes,
It
Lordship,
is not in supersession of this.
it is in
subsequent 2012 is not in supersession
no,
of
it is in continuation of that.
continuation of
Yes,
that.
Lord. That is, I'm not saying that it is superseded. The notification said that it is in continuation of 4/11/2009 notification.
The controversy is answered by the notification.
Yes. Anything else, Mr. Dev?
No,
Any law in this part?
Lordship, with regard to interpretation of notification, that should be read in, there cannot be any bypass to that rule, that exemption notification.
This notification clarifies all situation, this 4th of June 2009. Now what remains?
No, this is limitation and we preferred the appeal on this ground only. But due to monetary limit, we have to withdraw that.
You also challenge that order.
Yes, Lordship,
But because of pecuniary limit,
Now
they
what
had to
is their
withdraw.
order?
that we have to withdraw that.
Also, the order of Assistant Commissioner I pray to be confirmed, Lordship. Page 20 is the order,
20.
Lordship. It deals with the facts of the case in great detail, Lordship. Page 20 is the order, Lordship.
Page 89. So this 29/5/2013.
29/5/2013, Lordship. Page 23, para 2.2 onwards. This is the discussion and
This is
finding,
a discussion.
Lordship. That it was commissioned later. All these facts are there, Lordship. He was discussed in great detail. If the first two questions your Lordship is convinced, Lordship, the third question may not be answered at all.
What is this?
Highly obliged, Lordship.
Approximate page 36, so we consider the appellate's order because reasoning is there. Page 36 onward.
Para number 5 is here, right?
Okay.
For hearing, item 9 to 11.
My lord, the issue in these appeals is relating to delayed payment of transport subsidy and levy of interest thereon. In a similar case, lordship, the state has preferred an appeal before the Honorable Supreme Court, which is pending, lordship. So perhaps that issue can be decided after the Supreme Court.
Still pending.
Still on concept of the respondent are in agreement that the controversy involved in this rate appeal is pending consideration before the Honorable Supreme Court. Wait for adjournment. Summer vacations.
Much of.
Item 12.
Yeah, please, your lordship. Lordship, this appeal is directed against an order passed by a single judge on 6/2/2018 in WPC 2820, which your lordship will find at page 98. Now, just before that, lordship, this is a case relating to promotion from the grade of storekeeper to supervisor store grade 2. And the DPC was convened in 2010, wherein the petitioner respondent hearing was not considered.
In the year 2011, he was already granted promotion, but the learned single judge considered his case against the vacancy of 2010 because two persons have refused to.
That is precisely the point which your lordship has to see. For a moment, if I can take your lordship to paragraph 12 of the judgment.
This is the only para.
I've had the submissions advanced by the learned counsel for the rival parties, and I have perused the materials available on record from communication dated 25/2/2010 NHS 6 of the writ petition. It can be seen that the instruction of the directorate was the incumbents who have qualified for the departmental examination should be adjusted for consideration of their promotion before the departmental examination were conducted again from the year 2010. The petitioner admittedly cleared the departmental examination in the year 2003. There is no dispute about it. And in view of the two incumbents, that is Sri Narayana Pillai and Rajendran S, who had declined unconditionally despite their promotion issued by promotion cum posting order dated 11/3/2011, two vacancies were created. Now, what was playing in the mind of the learner single judge was, since
Vacancies became available. It's not created, available.
available. So what was in the mind of the learner single judge was, since these two persons did not avail of their promotion, he could have been very well adjusted there, the petitioner. Now, if I may take your lordship for a moment to page 50.
1-5.
50. It is a part of the affidavit, part of paragraph 3. I'm taking your lordship to the chart at paragraph 50.
Yeah.
Now, lordship has noted from the judgment that 75% will be by promotion, 25% by direct recruitment. Of the 75, there are two criteria. One is who have passed departmental exam. The second is
Merit comes in.
no, the second is who has not passed department without the. Now, if your lordship sees the quota position in the first chart in page 50. 21 without BE's departmental exam, without departmental exam passed, and 11, I'm sorry, 21 with departmental exam passed. Now the petitioner falls in the category.
Mr. Dev Chaudhary,
Lordship.
see, before you go here and there, please tell us what is the case of the union? As we have already seen, 75% by departmental examination.
No.
By promotion.
75% by promotion.
From promotion. Now, this 75% has two distinct
Yes.
categories.
Yes.
One is from amongst those who have cleared the departmental examination, and other is in terms of seniority.
Other is those who have not appeared in the departmental examination.
All right, those who have not. So there has to be some criteria.
Yes.
So let us take it that those who have not appeared, for them it will be seniority
Yes.
will be the dominant criteria.
Yes.
Now the writ petitioner has cleared the departmental examination.
Yes.
So subject to correction, as we could understand, he says so many vacancies were to be filled up from the D cleared candidate.
Yes.
So since these two persons declined to accept their promotion.
That is why. These
Listen,
two
listen,
persons were in
listen.
the category who. did not-
1 minute.
Yes.
This is the finding. We are going
Yes,
by the
yes,
finding of.
Yes.
Since these two persons have declined to accept their promotion despite having cleared the DE,
That is not there.
that is not the case. All right.
These two persons did not appear in the deal. So their case was separate. So far as the petitioner is concerned, he has passed the deal.
So he falls in the category of this departmental examination passed.
So
And
there,
those two persons who declined their promotion were from
In
the
the other
category
category.
without DE pass.
yes, Lordship. That is the case.
But who was senior amongst the the petitioner?
Yes, Lordship.
Is anyone junior to him who has been promoted
No.
In the
not
category of non-departmental examination?
In the non-departmental.
What fundamentally are finding unacceptable compared to the different? If you appear in the D, then you are disadvantaged to get promotion against the other provider. That's the position. So suppose नीचे जूनियर चार बंदे suppose और हमने डी दे दिया लेकिन जो 21 में है वो 21 कंप्लीट हो गया तो मुझे वहां नहीं लिखना है। अगर हम डी नहीं देते तो इसमें हमको नहीं रखा लेकिन उसकी डी दे दिया तो हमारा सुपरस्टिशन हो गया जो नहीं दिया वो हमारे से जूनियर है पर चलेगा नहीं दिया तो उससे पता है तो जूनियर लगे फंडामेंटली मैं वही कह रहा हूँ ये सब क्राइटेरिया अंडरस्टैंडिंग लेकिन क्योंकि मैंने डी दिया तो 21 खत्म हो गया तो दूसरा 21 में मुझसे जूनियर और आदमी भी आगे निकल जाएगा क्योंकि उसने डी दिया ये तो 16 का वायलेशन बात वही है नवोदय जूनियर को ले रहा हूँ तो इसका कोई कैसे नहीं है एकदम पता Has anyone junior to the writ petitioner being promoted
In both the categories.
in either category?
So far as
Whether D or non-D, either category for that year?
non-D lordship, I am not, but the D, no, nobody.
No, non-D.
Non-D lordship, these two persons were the senior most, they declined. When they declined,
No, we are asking
yes,
person junior to the
no,
petitioner. Sure about that.
lordship.
No, only on that point, not the.
Paragraph 11, 12, I'll refer.
Anybody junior to the petitioner has been promoted in the non-D category.
Lordship, in fact, that was not required as per their instruction itself, Lordship. Each,
We are not asking you whether it is required or not. We are asking you whether anybody was promoted or not. If you know the answer, say yes, or else you say you don't know.
no, I don't know.
Say that.
Now subsequently lordship, he was, by a review DPC, he was granted promotion with effect from 2011, and nobody junior to him has superseded him, lordship. And the other persons who had declined earlier, they had accepted it in 2013,
You can see non-D.
that other category, lordship. Perhaps, lordship, that, that thing, did not occur in the mind of the learned single judge. Lordship. That is my case, lordship.
Yes, may I? Lordship, may kindly turn to page 47 one.
47.
Yes, Lordship. That was what was referred to in paragraph 12, Lordship, of the judgment passed by the Honorable Single Judge. The third line,
47, yes.
the third line, Lordship,
Department of Pure, you read from the start.
Lordship. Departmental examination for consideration of promotion from grade B employees to LDC and SKT to SS grade 3. Reference your facts so and so February 09 sufficient departmental exam qualified SKT available for promotion to SSS. SS2. Hence, existing departmental exam qualified SKT may be adjusted first. So this was ignored by the department, Lordship, and that was taken into consideration by the
Hence, existing departmental
Will the exam-
examination qualifier may be adjusted first.
Lordship. Now, page 104, Lordship, may kindly please.
Departmental examination. But here to, these things don't matter. Nobody knows. And the procedure. Yes.
Lordship, page 104, paragraph 11, Lordship.
Yeah.
Heard so and so, the learned senior counsel for the petitioner, however, submits that in the DPC of 2010, which was held with effect from 8/11/2010 to 20/11/2010, the two recommended incumbents, viz. Sri Narayana Pillai and Rajendra S., who were recommended from the 15% earmark for incumbents who did not pass departmental examination, Lord, declined their promotion unconditionally. The review DPC should have considered the case of petitioner by reviewing the DPC of 2010 and not the DPC of 2011, since there were two clear vacancies. He submits that two other incumbents who were considered along with petitioner by review DPC of 2011 are junior to the petitioner. Therefore, the promotion of the petitioner should be considered by reviewing the DPC of 2010 and his seniority counted with effect from 2011-2010. Now, paragraph 12, Lord.
This point, this argument of junior to the petitioner, how they are junior?
Lordship, there were other two incumbents who were considered for promotion in 2012 for the review DPC of 2000 with effect from 2011, Lordship, and those two were junior to the petitioner. That was what was referred to, Lord.
Which two? Which two?
The DPC which recommended the petitioner's promotion, Lordship, considered two other incumbents along with the petitioner.
Who were those two incumbents?
Lordship, those two are.
Then you have to file a fresh writ petition challenging that.
No, I am not challenging that, Lordship. Lordship, otherwise that the petitioner cleared his departmental examination and the two who unconditionally forfeited their promotion, Lordship, they did not clear the departmental examination. Was considered by the Honorable Single Judge, Lordship. That's what I am pointing out.
That they were considered against that 21 seats only.
Lordship. 21 seats.
21 seats were for the persons who have qualified this departmental examination and 21 for who have not qualified their examination. So
That was there, Lordship, but subsequently that notification at page 47 came in, Lordship. And due to that notification, we were given priority, Lordship. Since these persons, what had happened, Lordship, they completed their departmental
there is
examination.
the discussion of this notification by the learned single judge. He is not placed blank on that.
Yes, Lordship, it's there. It's Annexure 6, paragraph 12, Lordship.
Yeah, read.
I have heard the submissions advanced by the learned council for the rival parties, and I have perused the materials available on record from the communication dated 25/2/2010. This is the one, Lordship.
Yeah.
That was considered Annexure 6 to the repetition of the repetition. It can be seen that the instruction of the Directorate of ERO was that incumbents who have qualified in the departmental examination should be adjusted for consideration of their promotion before departmental examination were conducted again from the year 2010. That was the consideration, Lord.
The adjusted means even if 21 vacancies are filled up, even then they are to be adjusted.
Why this came in, Lordship? In 2003 itself, Lordship, this person, petitioner had passed the departmental examination. And from 2003 itself, Lordship, these persons were being promoted basing upon the results of those departmental examinations conducted in 2003 itself. From 2010, Lordship, what the department did, they,
These facts are not available before us. These whatever story you are telling,
Lordship,
are these part of pleading?
yes, Lordship. These are, Lordship, paragraph 7 of the page 101, Lordship.
DTE is the DTE is the
Directorate,
director,
directorate.
directorate. This 47, this you are referring to annexure 6, this is the annexure 6.
Yes, this is annexure 6. इसी को रेफर किया पैरा 12 में नीचे 25 फरवरी अच्छा ये नीचे
This is the original. This is copy. Original facts.
थोड़ा क्लियरिटी नहीं है
And Lordship,
Examination promotion from temporary residency. Departmental exam for LDC may be conducted from this year and from the next year. Sufficient departmental exam qualify SKT for promotion, hence existing may be adjusted first. Existing departmental exam qualification SKT may be adjusted first.
Yes.
इसका क्या मतलब?
Lordship, Lordship turns to paragraph 7 of the judgment of the Honorable Single Judge. That will be clear, Lord. Page 101, Lord.
7. Yeah, read.
In reply to the application was given by communication dated 10/4/2012. In the reply, amongst others, it was stated that all candidates who passed the departmental examination in the year 2000 were promoted, while those who passed in the year 2003 were considered for promotion up to the DPC of 2010, held with effect from 8/11/2010 to 20/11/2010, or the vacancy fell up to 31/10/2011. It was further stated that as per the instruction of the director dated 25/10/2010, departmental examination is to be conducted every year and no waiting list is to be maintained. Therefore, fresh departmental examination was conducted on 26/12/2011 for selecting candidates for promotion to supervisor store grade 2 in the DPC held with effect from 30/3/2012 for the vacancies up to 31/12/2012. Only those candidates who passed the departmental examination conducted on 26/10/2011 are to be considered for promotion in the DPC, and the departmental examination cleared by the candidates from the previous list of 2003 were forfeited. The petitioner, having not appeared in the departmental examination conducted on 26/12/2011, would be considered for promotion on the basis of his seniority from the category of incumbents who had not cleared the departmental examination. Subsequently, Lordship, may I read further, Lordship?
Accordingly, the petitioner communication sent by the secretary.
That was their
This
stand, Lordship.
this was a Lordship. This was wrong on the department, and therefore, Lordship subsequently, review DPC was conducted and he was promoted, Lordship. This stand that those who had passed earlier will not be considered was a wrong committed by the.
So the learned single judge has now directed a review of the review DPC.
He says the DPC of 2010 has to be given, but 2010 the vacancies were filled. 21 candidates were filled. In the category of those who had passed the departmental exam, 11 candidates were there, and he did not fall within those 11. So he did not get. Subsequently, when this clarification came from the department that they had to be considered, therefore there was a review DPC again, because in between there was a.
Those persons who have cleared the examination in the year 2003, those candidates was considered.
Yes. And for that reason, the review DPC was again conducted in 2011, and the petitioner along with 2 others, they were promoted.
So what is the effective relief we'll get? It's just seniority.
And no person, seniority of other persons are not going to be affected. Then why you are?
What is there in this writ appeal? Why you have filed it?
Lordship, I will not say why I have filed it. It's before my time, so I'm continuing with it.
At least you just suggest us what's the.
But no, 2010, there was no vacancy for the petitioner. Therefore, he could not have been adjusted in 2010. And 2011, Lordship, he has been given.
Okay, pass the order.
Yes.
Yes.
Item 13.
Right.
In this appeal, Lordship, I'm appearing on behalf of Learned Advocate General Lordship.
Yeah.
Lordship, today I'm praying for some accommodation, Lordship, due to some personal.
Yeah.
But your lordship, my senior is on legs.
Lordship, yesterday also.
Seeking some
Shivaji.
accommodation, whether it's to be urgent or not.
No, sir.
Yeah. After the summer vacation, yes.
Item 14,
Validity of rule is under challenge.
Yes, my lord. Proviso to Rule 55 of Assam Secretariat Service Rules 2019.
There is the Advocate General,
Lordship, I'm appearing on.
but the validity of the rule is under challenge.
Yes.
Notice we get that. So the validity of the rule or any provision of the act is under challenge. Advocate General.
Yes.
We,
That's true. That's true.
If Lordship comes to the prayer, Lordship,
whatever the prayer may be.
Lordship, two prayers are there,
To
Lordship.
quash and satisfy the provision sub rule 5 and rule 5 of the Assam Secretariat Rules 2019.
Yes, Lordship,
Yes.
that subsequent prayer, Lordship, may kindly see.
Nature of setting aside quashing of the order dated Chief Secretary.
Lordship, under the same rule, there is a relaxation clause. They filed one representation and that representation was dismissed by the
That's
department.
a different one.
But ultimately, they are saying this rule, validity of the proviso to rule 5
Yes,
is under challenge, then
yes,
you have to hear the Advocate General for that.
Lordship, no issue, Lordship. I will convey it with the learned advocate.
Okay, Mr. Kimac, appearing for the respondents, I submitted that the Advocate General would appear in the matter. It seems the validity of proviso to sub rule 5 of rule 5 of the Assam Secretariat Service Rules 2019 is under challenge. List after summer vacation by showing name of Mr. Learned Advocate General in the, while reflecting the name of Learned Advocate General in the quasi list.
May prefer a date if possible, my lord.
Summer vacation after that, whatever it may. And summer vacation date, so don't ask for.
Yes, yes. Fine.
item 16,
Deeply.
My pleasure. What photo? Yes.
But the contract was awarded by the present appellant to the respondent number 5. And that respondent number 5 had subcontracted to the respondent number 1
Payment. The
Yes.
subcontractor asked for payment.
payment.
There is a provision under the agreement itself.
Yes, that it won't be given to the subcontractor. All the payments, everything has to be through the contractor. We don't have any PVT of contract with the subcontractor. We don't have any PVT of contract with the subcontractor. Rather, the contract is with the respondent number 5.
That was after your approval, this subcontract was executed.
Yes, this, it has the condition, therein, that all the liabilities, whatever, that will be attached to the contractor, and all the payments, whatever, that will be through only the contractor. We don't in fact recognize the subcontractor as such. This approval is only with regard to two aspects of the matter in the national interest and its viability. That is the
The contractor is not interested in that.
On true ground, Honorable Single Judge has allowed the writ petition. Firstly, that Honorable Single Judge has found, my lord, that we have admitted the liability. Number one. Secondly, that work is incomplete. Work is completed in all respects.
Yes.
And thirdly, the subcontracting was an assignment. These are the three, my lord,
The agreement between the contractor and the subcontractor was executed with your consent. With your approval. This is what the learned single judge observed. And in that agreement, there is a condition. In case the contractor failed to pay the subcontractor, the NHIDCL will pay the amount.
my lord, with all respect, my part, that is not the clause, my lord. At any rate, we don't, my lord.
Mr. Saikia,
Yes.
there is one aspect of the matter. I think it is section 70 of the Contract Act. You see, once it is done with your approval,
Yes.
can you say you don't have any privity of contract? This will be amount to a quasi contract.
My lord, that is, my lord, so far as the section 70 principles, my lord. That is, my lord, that way, my lord, that is all right, my lord. But here, my lord, this was not in that my lord, mode, my lord. Now, we never accepted that the amount is in completion of the entire work. My lord, the
And the-
entire, so far as
Sir, the learned single judge observed the admitted facts which are, the contract agreement is in question of 1911 permits subcontract
Yes.
between the contractor and the NHIDCL. The subcontract of the petitioner was given after approval from the concerned respondents, you.
Gotcha.
Various reports which are part of the record would demonstrate work which was entrusted to the petitioner was completed in all respect. In fact, this fact is also admitted by the learned counsel for the respondent. There are various clauses in the contract from which the petitioners appear to assign the principal. Numerous communications, including so and so, fortify the extent of the petitioner. The respondent number 3 and 4 in the affidavit, they have said so and so, so and so. These are the facts which the learned single judges, the only reason discernible from the refusing payment of the principal contract did not perform the portion of work leading to termination of the contract at risk and cost of the contractor. However, the gross valuation of unpaid work calculated rupees itta, which was executed, out of which the work done was the petitioner of only 11 crore and something.
So, my lord, the total subcontracting amount to the my lord, respondent number 1 was about 60 crores.
Yeah,
Total, my lord.
no, 11 crores.
11 crores, my lord, that is the valuation of the unpaid work. That is as per the terms. This amount again subject to the, my lord, the already advance payment made, or the damage and the liability that is in the tender and the documents, my lord.
Okay.
Mainly, my lord, clause 3.2 at page 61, my lord.
This agreement is
Between the present appellant and the respondent number 5.
respondent,
Contractor.
this subcontract.
No, my lord, this is the main contractor. This agreement is with the main contractor.
Respondent number 5 is the contractor.
Respondent number 5 is the contractor. He is the respondent number 1 presently.
Okay.
That is
So
subcontractor
this agreement is between respondent number 5 and the appellants.
appellants.
Yeah.
Gotcha. Now, clause page 61, my lord, clause 3.2.1.
Obligation.
Obligation relating to subcontract and any other agreement. The contractor shall not subcontract any works in more than 70% of the total length of the project highway and shall carry out works directly under its own supervision and through its own personnel in at least 30% of the total length of the project highway. Provided, however, that in respect of the works carried out directly by the contractor, it may enter into contracts for the supplier and installation of materials, plant, equipment, road, furniture, safety devices, and labor as the case may be for such works. For the avoidance of doubt, the parties agreed that the contractor may subdivide the at least length of 30% in no more than 5 sections of the project highway. Till this one, that the contractor has to execute 30% and the 70% he can give it on the subcontract. that is the tax calculator. The next line, the parties further agrees that all obligation and liabilities under this agreement for the entire project highway shall at all times remain with the contractor. All the things will be, now the next clause, page 62. Clause 3.2.2, what the present appellant looks into the subcontractor, it is with the purview of the public interest and national security. No other qualifications are seen here. Now, we'll find
So what is, you are referring page 62, you are referring to?
62 page 3.2.2.
Employment of foreign national, nay, this, in the very event of subcontract for works.
Or the aggregate of such subcontract with any subcontractor exceeds 5% of the contract price, the contractor shall communicate the name and particulars, including the relevant experience of the subcontractor, to the authority. Prior to entertaining into any such subcontract, the authority shall examine the particular of the subcontractor from the national security and public interest perspective and may require the contractor no later than 15 business days from the date of receiving the communication from the contractor not to proceed with the subcontract, and the subcontract shall comply therewith. It means they can engage the subcontractor within 15 days, the particulars to be given. And on the perspective of public interest and the national security, they will see, and if they find it doesn't suit, in that case, they have to, this contractor has to stop the execution of the work by the through the subcontractor.
So what is the relevancy of this project? Are you disputing that this person is not in the interest of this national security or what?
No. Then that is only two perspectives what we see on the subcontractor. That's what I wanted to highlight here. Now you'll also be see the approval.
Yes.
Find at page 175. This is the approval letter. Approving the subcontract by the NHIDC. Should I skip the first part, Miller? Clause 5, in case of failure of subcontract either to execute the work within the time or of required quality, at all the actions as mentioned in the contract agreement shall be initiated against the contractor. So even if the subcontractor defaults in anything, then the action will be initiated against the contractor.
You are referring to page 175 clause?
175 clause 5 in the next page.
5 on the
176 clause 5. Roman
in
5.
case the failure of subcontractor either to execute the work required, all the actions shall be, yes, we can.
Actually. But it's that subcontractor is not liable to us, nor will be holding him responsible for anything, because we know only the contractor to that extent. Then clause 11, your lordship can be similar.
Yes.
All payments shall be made to the contractor strictly as per provision mentioned in Schedule H of the contract agreement. No payment shall be released directly to the subcontractor unless the contractor and the subcontractor both jointly submit a written request to transfer the payments in the joint account held jointly by the contractor and subcontractor. If here there was no application for payment to the subcontractor, or there was no joint account as such. That's it. Now, let me come to clause 23.5 at page 143, because the contract was terminated. 143.
Yes.
143. This clause 23.5.
Yes.
This termination starts from 23.1. termination of the contract at page 140. My lord, I'm taking directly to your lordship to the clause 140, page 143, clause 23.5. At page 143.
Yes.
Valuation of unpaid works within a period of 45 days after termination under clause 23.1, 23.2, or 23.3, as the case may be, has taken effect, the authority engineer shall proceed in accordance with clause 18.5 to determine as follows the valuation of unpaid works. Value of completed stage of the work, less payment already made, reasonable value of the partial completed stage of work as on the date of termination, only if such work conforms with the specification and standard, and value of maintenance, if any, for completed months, less payment already made, and shall adjust from the sum thereof any other amounts payable or recoverable as the case may be in accordance with the provisions of this agreement, and all taxes dues to be deducted at source. But the amount what he has quoted, that 11 lakhs, it is on measurement of this particular.
Yeah.
Sorry, crore. This amount is only on measurement of valuation of unpaid works. The works has been measured, it came to 11 crores or not, my lord, and subsequently, my lord, these payments has to be adjusted thereof. This has not been done till then, my lord. That clause 23.6.1 again, my lord. Next page, page 44, termination payment. But after calculation of all this amount, then the amount that will be payable to the contractor arises, that is termination of payment. That is at page 144, 23.6.
Yeah.
Termination of payment. Upon termination on account of contractor default under clause 23.
So this contractor has not completed the work. How much work was completed by him?
Total work,
Either by himself, by the contractor
Total-
itself, or by the subcontractors.
total works, my lord, he has completed 1.8%, my lord, as per the termination letter, my lord.
Only 1.8%.
Total lordship, my lord.
Okay.
So out of that, my lord, that is 437 and odd crores, my lord, the total valuation. Subcontract was about, my lord, 60 crores and odd.
Okay.
And out of that, this amount is only 11 point and odd crores, my lord. So there's no question of completion of the work. Nowhere we have said, my lord, we have completed the, he has completed the works, or this is payable. The amount is the works which was executed partly or fully, that has to be measured.
You do one thing,
Lordship.
you give us a chart
Lordship.
that this was the work. That work was, that much of work was completed by the contractor, and that was the remaining work has not been completed. Then the work done by the subcontractor.
Right.
There may be 2, 3, 4 subcontractors, or only one subcontractor is there.
What it appears from the record, there two contractors were there. Out of 12 crores and odd, 11 crores was executed by him, and 1 odd crores was executed by someone else.
Give us a breakup.
Lordship.
You give us a breakup, so it may at least picture be clear that how much work was done and how much work was left with them.
And it is also not his case. It is also not his case that he has completed his work. The writ petition, he did not say my lord, that he has completed the work.
Judge has recorded your statement.
There, my lord,
He has completed
Yeah,
the
but
work,
that
and
what, my lord,
that is there.
Lordship, that is there, but what it, my lord, that may not be supported by these, my lord, the various statements.
Okay, you give us a chart and give all these things there.
Lordship.
Mr. Saikia, as my lord, the Honorable Chief Justice has mentioned, a pictorial representation of what is the exact reality at the ground level would be of immense help. But side by side, there is another thing. Please come prepared to address the court on that. See, as per the contract, all liability will be in the contractor. Correct. But you have recognized the subcontractor and he has done some work. So even if there is a violation of the contract agreement, your claim, your actions can all lie against the contractor, not against the subcontractor.
Yes.
Right? Now, whatever admitted work he has done, what if we say that you pay him and proceed against the contractor for recovery of the same? Then also it is in consonance with the terms of the contract. This we are saying, because we have taken cognizance of the fact that there is a subcontractor. So here, why can't we examine the matter from the touchstone of fairness in under Article 14? Because you are a public authority, correct? And the subcontractor never intended to do the work gratuitously. Right? So beyond strict terms of the contract, the appellants being an authority under Article 12 would also have a duty to act fairly. So if there is an element of loss or contractual breach, you can always proceed against the main contractor. But why penalize him? Merely hiding behind some technicalities. This is a question we are putting it to you. Please address the court on that. And this may have some relevant bearing in this matter. Because yes, whatever, the main contractor has certainly taken its hands off the whole thing. That may be in strict in breach of the contract agreement, and there may be remedies available. But we are thinking, why should the subcontractor suffer?
Subcontractor should suffer.
Because he has done the work, he has made his investment. And to that extent, we may also recognize a quasi contract in this. To that extent. So please come prepared. on that.
I'll detail address, my lord, I'll be meeting on that point, my lord. But here, what would happen, my lord, in that case?
Another thing is the learned single is observed that as per clause 27(12), the agreement shall be binding upon the injured and the benefit of the parties and their respective successors and permitted assigns. That is also taken into consideration.
No, my lord, here clause 24 point, if your lordship looks into the clause 24, my lord. Page 157, 147, my lord.
How long to prepare the chart?
Just 2 weeks perhaps will be required. So authority will be, my lord, they'll be exercising the things, I have to communicate them.
Lordship, even the headquarter approved the amount for paying to the subcontract. So there is no dispute, your lordship, maybe please to come to page 482.
You are opposing the request to prepare a chart. Are you opposing it?
Chart is already there, here, on the record, that's right. I am not opposing, your lordship agree to,
Let him,
That my
he
learned-
has made some certain submissions because it's not a small amount, 11 crore rupees amount is there. He's saying if you have not, their statement recorded by the learned single judge, the work has been completed and anything else.
that is not correct, lordship, sufficient documents are here, lordship.
Let him file a chart of this
Okay.
to understand the controversy. Make it after summer vacation.
Yes.
Colored representation, that will be easier.
Possible. Just after summer vacation.
Yeah, my lord, basic, my lord, the things that the honorable single judge has held, it is, my lord, assignment. That would, my lord, give, my lord, the entire, my lord, the contract, because this is a contract.
Maybe you first
Terms
the
and
chart,
conditions.
then we'll consider your argument. We'll consider your.
Lordship, fixed date may be given.
After summer vacation, immediately after summer vacation.
Lots.
Item 18,
Meet Mr. Lordship. Here, Lordship, the issue before Lordship is whether a anticipatory bail can be filed by a juvenile Lordship.
That Supreme Court Supreme Court has withdrawn that.
That has been disposed of. The issue is left open, Lordship.
There is a conflicting judgment, sir.
There is a conflicting judgment.
Lordship, I have come across a recent judgment of Honorable Punjab and Haryana High Court of 2095. It was in favor of the act.
It suggests what maintainable.
Elaborate.
And what about the other high courts?
That's I got one from Allahabad High Court. This is This is also in favor of my prayer, Lordship.
In the judgment, everything has been elaborated, like who are the judgment, like courts who have given judgments in the favor of the appellants.
Have you seen these judgments?
29-5.
29, I have not compared.
This is only on 29th of February,
Yes.
sorry.
May, my lord.
May.
Yes. It will keep up. Like so.
Because there are contradictory judgments on the different.
Everything has been reflected, your lordship, in the particular judgment. The courts which says entertain the application, it has been reflected. And the courts which has declined the prayer, it has been reflected in the resolution.
I'll pay for it. You have to allow that. Maintain the
Next, you, you are relying on this Punjab, Haryana, and you are relying on?
No, lordship,
I'm
I will
relying,
state, my lord, I'll.
She's not relying. She's
Yes.
saying that they're helping the appellant.
Okay, helping the appellant.
I'm
It's
relying on the,
Supreme Court, my lord,
I'm
it has
relying
come
on
up
the
on
Allahabad
reference.
High Court judgment, which says that anticipatory bail application is maintainable.
Where is that Allahabad High Court judgment?
I place the copy.
Shahab Ali, my lord.
Correct.
This Muhammad Zad.
Yes, Mohammed Zaid versus State of UP.
And what
Relevant
about
para-
and what about this, the petitioner? The Darshat Roy,
He is on interim bail
he is on interim bail.
Yes.
Okay, by this court.
by this
Yes.
court.
Okay. Okay, we'll examine these judgments,
Lordship.
both the judgments, because we have to take a call on behalf of the Guwahati High Court, so we'll examine and then.
Allahabad High Court, one of the judgments I have got, it says it's not maintainable. Shahab Ali minor,
Yeah, this is the latest judgment, 2023 judgment as later.
Okay.
It was 2020.
2023, actually, this is also 2023. Okay, we'll consider this and then. we'll take a call.
Lordship is hearing again.
After summer vacation, we'll decide. Okay. The matter comes upon before this court in view of the two conflicting views expressed by the two different benches of this court. Matter is full stop. The matter is regarding the maintainability of the bail application, interim bail application under section 438 of the 438 CRPC in the matters of Juvenile Justice in fact Care and Protection of Children Act 2015. Full stop. Learned counsel for the parties has placed reliance on the decision of the Allahabad High Court as well as the Punjab and Haryana High Court, wherein it is held that anticipatory bail application filed on behalf of the juvenile is maintainable under the provisions of Juvenile Justice Care and Protection Children Act 2015. Full stop. Let this matter be listed after summer vacation for considering the issue involved. Just after summer vacation.
I'm obliged.
Thank you.